Keep yourselves in God's love as you wait for the mercy of our Lord Jesus Christ to bring you eternal life. Be merciful to those who doubt. Save others by snatching them from the fire. To others, show mercy mixed with fear, hating even the clothing stained by corrupt flesh. Waiting for things is not only an important part of life, doing so with patience is a trait of a believer in God. We are in the space between the resurrection and the return of Christ. And as we wait, we show mercy, save others, and stand against evil. People are different, and each one will have a different temperament and personality, which, after all, is what makes life so grand and beautiful. And each one will have a different. Perhaps you work with someone who is anxious and filled with doubt. Be merciful, gracious, and kind. Maybe one of your friends is in grave danger. Act decisively and quickly, for time is of the essence. Does a family member need to be convicted of sin? Share with that person the total character of God and talk about love and justice. God is merciful to us and has placed people in our lives that we might love them, know them, and what they need. Father, there are times when I doubt and am in need of mercy. Make me aware of your mercy that I may be merciful. Other times the situation is pressing and I need an immediate evac. Help me see this in others. I know I have sins to be convicted of. So do that for me. Help me repent of my sins and point out others to repent of theirs. In the same way in which anything is constituted, it may be destroyed. An error which is not resisted is approved. He who derives advantage from anyone should bear that person's obligation. An exchange naturally creates a warranty. He who comes out of his monetary minority becomes legally a person. Extortion is a crime when, by color of office, any person extorts that which is not due, or above due, or before the time when it is due. That which is done cannot be undone. False in one thing is false in all things. Happy is he who has been able to understand the causes of things. Faith is an obligation of conscience of one to the will of another. Fraud lies hidden in general expression. Things general precede, things special follow. Things general are not derogatory to things special. He who is the prior in time is stronger in right. Man is a term of nature, person of the civil law. Enemies are those against whom we declare war, or who declare it against us. All others are traitors and pirates. To speak insufficiently is the same thing as to say nothing. Ignorance of the law excuses no one except Lord Coke in 1798 for ignorance of ecclesiastical law, marrying in private without license or publication, as against canon law, for all are presumed to know those things to which all consent. No one may come into court with unclean hands. In criminal cases, the silence of a person presents presumed consent. In civil cases, sometimes that of the person absent and even ignorant, where his interest lies, does the same. In favor of life, liberty, and innocence, all things are to be presumed. He truly acts fraudulent who, observing the letter of the law, eludes its spirit, equity. Error dwells in general expression. In law, no one is credited unless he is sworn. In all contracts, whether named or not, an exchange is understood. It is unjust for free men not to have the free disposal of their own property. A wrong is not to be presumed. Among many things, you will even question laws and learned men. A benefit is not bestowed upon one unwilling to receive it. A good judge may do nothing from his own judgment, or from a dictate of private will, but he should pronounce according to the law and justice. A judge cannot punish a wrong done to himself. To a judge who exceeds his office, no obedience is due. It is the duty of a judge to decide according to the facts alleged and proved. It is the duty of a judge to declare, not to make the law. The law does not suffer the same thing to be paid twice. The unwritten common law is expressed by the tacit and ignorant consent and customs of the people. False witnesses, form versus substance. Before an attorney can sue, he must show that the defending party breached the agreement. The attorney needs a witness to give testimony that there is an agreement and that the agreement has been breached. Trinsley versus Pagliaro clearly points out that an attorney can either be an attorney or a witness, meaning that his statements in argument and brief, although flattering to the court, are not sufficient for summary judgment or a motion to dismiss, meaning that if the lawyer is attempting to submit evidence into the court, it should be immediately challenged with an objection and stricken from the record based upon the foundation that the lawyer is unwilling to testify with firsthand perfected knowledge under the pains and penalties of perjury. So therefore, we impeach any evidence that an attorney would seek to put on record or supplant before the court or testify. If Rich testifies in court that there was a loan when he knew that there was only an exchange of equal value, Rich would be giving false testimony and would be called a false witness, which would be grounds for impeachment and to strike his testimony from the record. In a normal court foreclosure, the lender does not come to court to give testimony. The bank attorney uses the alleged promissory note with alleged borrower's signature as the witness in the court to claim that there is an agreement. That actual documentation brought forward by the attorney is actually a forgery. That there was a loan, that the lender fulfilled his agreement, and that the alleged borrower did not fulfill the agreement to repay the money. Instead of the attorney using Rich to give oral testimony, the attorney uses the promissory note, which is a copy of the promissory note, which is a forgery, which should be immediately objected to and stricken from the record as pursuant to the rules of Federal Rules of Evidence 1002. You have a right to examine and inspect the original document as the witness and as the evidence to sue the alleged borrower. There is a legal concept of form versus substance. This is equity. Equity disregards form and looks at the substance. The form is the promissory note, which says that the lender lent money to the alleged borrower. The substance is the money trial, the book keeping entries. The substance shows that there were two loans exchanged, equal value for equal value, paper for paper. The borrower was required to repay his loan to the bank plus interest, but the bank never repaid the debt it owes. IOU was exchanged, check from checkbook monies was exchanged for IOU. The other IOU would be the security agreement promissory note with the credit application. The two newly created IOUs cancel each other out. Substance, true transaction, shows that the borrower was the lender to the bank, in which the bank received by deposit the alleged borrower's promissory note, credit application, and security retail installment agreement or security agreement. Then the bank repaid the loan from the borrower to the bank. The form, the alleged bank loan agreement, shows the opposite. Example, you sign a paper that says you were lent $10,000, but no one lent you 1 cent to obtain the promissory note. A thief stole $10,000 worth of diamonds from you, sold them for cash, and returned the cash to you as a loan. The form says that there was a loan. Your signature also says that there was a loan. The true transaction and nature of the transaction, though, proves that there was no loan. The substance, the money trial, and the bookkeeping entries proves that someone took something of value worth $10,000 from you, the promissory note, the credit application, and the retail installment agreement, exchanged it for a different asset of equal value, and returned your $10,000 to you as a loan that you now have to pay off with interest. The attorney sues you, claiming that your signature proves that you received the loan. You hire an expert witness to prove that there was no loan, that the substance of the true transaction and nature of the transaction was for private household consumer goods tax exempt, was an exchange, and that you were charged as if it were a loan. Economically speaking, what is the difference if a stranger received your $10,000 worth of diamonds for free, or if he got a $10,000 lien on your property for free, or if he received a $10,000 of your future payroll checks for free? The substance of the transaction and nature of the transaction is the transferal of $10,000 of property from you to the stranger for free. The transfer of wealth is precisely how bankers obtain liens on the nation's homes, cars, farms, and businesses for free. If a robber were to use a gun to transfer your wealth, you would place him in prison. If a banker does the same thing by using form, an attorney, a judge, and a sheriff or police officer, you think it is legal. But it is not legal, nor is it lawful. It's an unlawful conversion and a desecration of your unalienable rights to be made whole. Does the attorney use the promissory note just like a witness to give false testimony in court? He actually uses a forgery. It's a copy, and as a copy, it's a forgery. And you would immediately strike that from the record, object to it being a forgery, and tell them that you demand they bring the original instrument forward for your inspection, claiming that the lender lent money, cash or cash equivalent, to the alleged borrower. The attorney could be disbarred for bringing fraud into the court. The substance was an exchange of value for value. If the form and the substance disagree, one must rely on the substance over the form, which is equity, because substance always wins over form. Example, you give Rich $100 for 5 boxes of toys. Rich says, "Here are the 5 boxes." Signs this paper that says you received the boxes. That's a receipt or a bill of lading for the purchase of the goods. Rich refuses to hand over the 5 boxes and claims that the form, the paper you just signed, says that you received the boxes. You would tell the judge that you acted in good faith, which is equity, by signing because you were told that you would receive the 5 boxes standing in front of you. After you had signed, Rich refused to let you have the boxes. That's theft by way of false promise, unlawful, unjust enrichment, and the form, the paper, says that you received the boxes, but the substance, the true transaction, the nature of the transaction clearly shows you never received what you had bargained for in good faith. If the attorney uses the form, paper, in court to claim that you received the boxes when in fact he knew that you had never received them, the attorney brought fraud on the court to sue you. The form, the paper, would be a false witness against you, as well as the attorney now acting in the capacity as a witness, who should be removed from representing anybody at that point, because they're unlawfully and illegally submitting evidence into the court as though they are a witness, which means you need to subpoena them because they can either be an attorney or the witness. They cannot be both. Is the promissory note used as false witness? The promissory note has the borrower's signature agreeing to the lender lent the borrower money. Again, the evidence that is submitted before the court is a forgery. It's a copy. It is not the true original documentation. The people disagree that one who provided the original funds to fund the bank loan check should be repaid the money. Few argue that we should have equal protection and full disclosure. The lenders concealed the true substance in the agreement, the nature and the cause of the transaction. If a banker receives $10,000 of capital from Joe and deposits the funds into a checking account, should the bank return the $10,000 to Joe? If all bankers agree that the answer is yes, then all bank loans in America should be canceled tomorrow. If the bank received $10,000 from Joe and lent the same $10,000 to Joe, should the bank return the $10,000 to Joe? The foreclosure attorney must argue that the bank should not return the $10,000 to Joe. Joe believed that the alleged borrower should repay the lender, and the lender should repay the one who funded the bank loan check. The foreclosure attorney must argue that the parties agreed to the terms and the one who funded the loan should never be repaid the money. How would the judge rule in favor of the bank, claiming that the one who funded the loan should never be or never ever be repaid the money? Imagine faxing that ruling to everyone in the nation. The attorney wants only the form, the promissory note with your signature as a witness in court. You want the true substance, the true transaction, the nature of the transaction that was done in good faith for private household consumer goods, and the whole truth and nothing but the truth without the masses of the people joining. You will remain in debt. We need you to join in copying and distributing the brochure. Keep in mind that the signature on the promissory note is always used as a witness against the borrower to create a situation in which the borrower automatically incriminates himself, self-incrimination. Some attorneys object to allowing the bookkeeping entries being entered into the court as evidence, and that is why we request and demand and subpoena the MoneyNet Daily Log Transaction Report 120, which shows the source of the funds and the destination of the funds being you. The attorney must rely on the form and stop the substance. Extortion occurs when the court does not allow information into court for one's defense. It's also denial of due process of law, stripping the court of any jurisdiction it may have had. How does one get the substance into court? One needs a CPA expert witness to bring substance into court. There are ways to get past financial statements of banks that have gone out of business even up to 10 years ago. The CPA expert witness needs to use notice and bank financial statements to prove substance over form. Obviously, bankers may read this book, so the secret for the expert witness cannot be revealed here. However, you can expect the judge and the bank attorney to attempt to stop the CPA expert witness from testifying, which if the judge did that, that would be tampering with a witness. That's a felony. It's a crime. It's a breach of his oath of office. It's a breach of trust. And you have to object on it and call him out on it and force him to recuse himself or fire him. I believe that the CPA testimony could disbar the attorney. If your CPA testifies, the bank needs to bring in an expert witness itself to counter your expert. Now you have 600 questions from Volume 2 to ask the bank expert witness. I do not believe the bank expert will want to testify knowing that you have 600 questions that he must answer. What would happen if 200 people in every state were committed to copying and distributing 3 brochures every day as they went to the gas station and the grocery store? Just 3 brochures a day calculates to 1 million brochures distributed every month. How long would it take before attorneys decided to join us and stop the foreclosing? If you were an attorney and believe that 5% to 10% of the population will learn the truth, would you continue to foreclose? Be an accessory after the fact of unjust enrichment, theft by way of extortion, simulated legal process, and sham legal pleadings? What if you believe that it was just a matter of time before everyone would find out and would want justice, and you would be disbarred? Would you stop working for the bankers and join the people? Brochures are very important to winning the nation. Without the masses joining, you will remain in debt. We need you to join in copying and distributing brochures. When the politicians believe that there are enough voters to vote them out of office, the politicians will vote in Tom Shaw's banking solution or be voted out of office. At that time, the politicians will listen to the people and turn against the bankers. The witness stand. This is a hypothetical illustration which represents a combination of real court cases, depositions, and interviews with bankers that I have witnessed. The banker was placed on the witness stand and sworn in. The plaintiff's borrower's attorney asked the banker the routine questions concerning the bank's education and background. The attorney asked the banker, "What is Court Exhibit A?" The banker responded by saying, "This is a promissory note." The attorney then asked, "Is there an agreement between Mr. Smith, borrower, and the defendant?" The banker said yes. The attorney asked, "Do you believe the agreement includes the lender and a borrower?" The banker responds by saying, "Yes, I am the lender and Mr. Smith is the borrower." The attorney asked, "What do you believe the agreement is?" The banker quickly responded saying, "We have the borrower sign the note and we give the borrower a check." The attorney asked, "Does this agreement show the words borrower, lender, loan, interest, credit, or money within the agreement? The banker responded saying, sure it does. The attorney asked, according to your knowledge, who was to loan what to whom according to the written agreement? The banker responded by saying the lender loaned the borrower a $50,000 check. The borrower got the money and the house and has not repaid the money. The attorney noted that the banker never said that the bank received the promissory note as a loan from the borrower to the bank. He asked, do you believe an ordinary person can use ordinary terms to understand this written agreement? The banker said yes. The attorney asked, do you believe you or your company legally own the promissory note and have the right to enforce the payment from the borrower? The banker said, absolutely. We own it and legally the right to collect the money. The attorney asked, does the $50,000 note have actual cash value of $50,000? Actual cash value means the promissory note can be sold for $50,000 cash in the ordinary course of business. The banker said yes. The attorney asked, according to your understanding of the alleged agreement, how much actual cash value must the bank loan to the borrower in order for the bank to legally fulfill the agreement and legally own the promissory note? The banker said $50,000. The attorney asked, according to your belief, if the borrower signs the promissory note and the bank refuses to loan the borrower $50,000 actual cash value, would the bank or borrower own the promissory note? The banker said the borrower would own it if the bank did not loan the money. The bank gave the borrower a check, and that is how the borrower financed the purchase of the house. The attorney asked, do you believe that the borrower agreed to provide the bank with $50,000 of actual cash value, which was used to fund the $50,000 bank loan check back to the same borrower, and then agreed to pay the bank back $50,000 plus interest? The banker said no. If the borrower provided the $50,000 to fund the check, there was no money loaned by the bank, so the bank could not charge interest on money it never loaned. The attorney asked, if this happened, in your opinion, would the bank legally own the promissory note and be able to force Mr. Smith to pay the bank interest and principal payments? The banker said, I am not a lawyer, so I cannot answer legal questions. The attorney asked, it is bank policy that when a borrower receives a $50,000 bank loan, that the bank receives $50,000 actual cash value from the borrower. This gives value to a $50,000 bank loan check, and this check is returned to the borrower as a bank loan, which the borrower must repay. The banker said, I do not know the bookkeeping entries. The attorney said, I am asking you if this is policy. The banker responded, I do not recall. The attorney asked again, do you believe the agreement between Mr. Smith and the bank is that Mr. Smith provided the bank with actual cash value of $50,000, which is used to fund a $50,000 bank loan check back to him, which he is then required to repay plus interest back to the same bank? The banker said, I am not a lawyer. The attorney said, did you not say earlier that an ordinary person can use ordinary terms and understand this written agreement? The banker said, yes. The attorney handed the bank loan agreement marked Exhibit B to the banker. He said, is there anything in this agreement showing the borrower had knowledge or showing where the borrower gave the bank authorization or permission for the bank to receive $50,000 actual cash value from him and to use this to fund the $50,000 bank loan check, which obligates him to give the bank back $50,000 plus interest? The banker said no. The lawyer asked, if the borrower provided the bank with actual cash value of $50,000, which the bank used to fund the $50,000 check and return the check back to the alleged borrower as a bank loan check, in your opinion, did the bank loan $50,000 to the borrower? The banker said no. The attorney asked, if a bank customer provides actual cash value of $50,000 to a bank and the bank returns $50,000 actual cash value back to the same customer, is this a swap or exchange of $50,000 for $50,000? The banker replied yes. The attorney asked, did the agreement call for an exchange of $50,000 swap for $50,000, or did it call for a $50,000 loan? The banker said a $50,000 loan. The attorney asked, is the bank to follow the Federal Reserve bank policies and procedures when banks grant loans? The banker said yes. The attorney asked, What are the standard bank bookkeeping entries for granting loans according to the Federal Reserve Bank policies and procedures? The attorney handed the banker Fed publication Modern Money Mechanics marked Exhibit C. The banker said the promissory note is recorded as a bank asset and a new matching deposit liability is created. Then we issued a check from the new deposit back to the borrower. The attorney asked, is this not a swap or exchange of $50,000 for $50,000? The banker said, this is the standard way to do it. The attorney said, answer the question. It is a swap or exchange of $50,000 actual cash value for $50,000 actual cash value. If the note funded the check, must they not both have equal value? The banker then pleaded the Fifth Amendment. The attorney asked, if the bank's deposit liabilities increase, do the bank's assets increase by an asset that has actual cash value? The banker said yes. The attorney asked, is there any exception? The banker said, not that I know of. The attorney asked, if the bank records a new deposit and records an asset on the bank's books having actual cash value, would the actual cash value always come from a customer of the bank or an investor or a lender to the bank? The banker thought for a moment and said yes. The attorney asked, is it the bank policy to record the promissory note as a bank asset offset by a new liability? The banker said yes. The attorney said, does the promissory note have actual cash value equal to the amount of the bank loan check? The banker said yes. The attorney asked, does this bookkeeping entry prove that the borrower provided actual cash value to fund the bank loan check? The banker said yes. The bank president told us to do it this way. The attorney asked, how much actual cash value did the bank loan to obtain the promissory note? The banker said nothing. The attorney asked, how much actual cash value did the bank receive from the borrower? The banker said $50,000. The attorney said, is it true you received $50,000 actual cash value from the borrower plus monthly payments, and then you foreclosed and never invested 1 cent of legal tender or other depositor's money to obtain the promissory note in the first place? Is it true that the borrower financed the whole transaction? The banker said yes. The attorney asked, are you telling me the borrower agreed to give you, the bank, $50,000 of actual cash value for free, and that the banker returned the actual cash value back to the same person as a bank loan? The banker said, I was not there when the borrower agreed to the loan. The attorney asked, do the standard federal publications show the bank receives actual cash value from the borrower for free and that the bank returns it back to the borrower as a bank loan? The banker said yes. The attorney said, do you believe the bank does this without the borrower's knowledge or written permission or authorization? The banker said no. The attorney asked, to the best of your knowledge, is the written permission or authorization for the bank transfer of $50,000 of actual cash value from the borrower to the bank and for the bank to keep it for free? The banker said no. Does this allow the bank to use the $50,000 actual cash value to fund the $50,000 bank loan check to the same borrower, forcing the borrower to pay back to pay the bank $50,000 plus interest? The banker said yes. The attorney said, if the bank transferred $50,000 actual cash value from the borrower to the bank in this part of the transaction, did the bank loan anything of value to the borrower? The banker said no. He knew that one must first deposit something having actual cash value: cash, check, promissory note, bill of exchange, letter of credit, banker's acceptance, trade acceptances to fund a check. The attorney asked, is it the bank policy to first transfer the actual cash value from the alleged borrower to the lender for the amount of the alleged loan? The banker said yes. The attorney asked, does the bank pay IRS taxes on the actual cash value transferred from the alleged borrower to the bank, which is found under Title 26, 2603, 2602, 2001, 2002. Anybody in constructive possession of decedent estate property is liable for the transfer taxes on a carryover basis. The bank answered no, because the actual cash value transferred shows up like a loan from the borrower to the bank or a deposit, which is the same thing, so it is not taxable. The attorney asked, if a loan is foreign, is it taxable? The banker agreed by saying yes. The attorney asked, is it the bank policy to return the actual cash value that they received from the alleged borrower unless it is returned as a loan from the bank to the alleged borrower? Yes, the banker replied. The attorney said, you never pay taxes on the actual cash value you receive from the alleged borrower and keep as the bank's property. No taxes is paid. said the crying banker. The attorney asked, when the lender receives the actual cash value from the alleged borrower, does the bank claim that it then owns it and that it is the property of the lender without the bank loaning or risking 1 cent of legal tender or other depositor's money? The banker said yes. The attorney asked, are you telling me the bank policy is that the bank owns the promissory note actual cash value without loaning 1 cent of other depositor's money or legal tender, that the alleged borrower is the one who provides the funds deposited to fund the bank loan checkbook money, bookkeeping entries, and that the bank gets funds from the alleged borrower for free? Is the money then returned back to the same person as a loan which the alleged borrower repays when the bank never gave up any money to obtain the promissory note? Am I hearing this right? I give you the equivalent of $50,000 cash, you return the funds back to me, and I have to repay the $50,000 plus interest. Do you think I am stupid? In a shaking voice, the banker cried, saying, all the banks are doing this. Congress allows this. The attorney quickly responded, does Congress allow the banks to breach written agreements, use false and misleading advertising, act without written permission, authorization, and without the alleged borrower's knowledge to transfer actual cash value from the alleged borrower to the bank and then return it back as a loan? The banker said, but the borrower got a check and the house. The attorney said, is it true that the actual cash value that was used to fund the bank loan check came directly from the borrower and that the bank received the funds from the alleged borrower for free? Is it true? Said the banker. Said the banker. It is true, said the banker. The attorney asked, is it the bank's policy to transfer actual cash value from the alleged borrower to the bank and then to keep the funds as the bank property which they loan out as bank loans? The banker, showing tears of regret that he had been caught, confessed, yes. The attorney asked, was it the bank's intent to receive actual cash value from the borrower and return the value of the funds back to the borrower as a loan? The banker said yes. He knew he had to say yes because of the bank policy. The attorney asked, do you believe that it was the borrower's intent to fund his own bank loan check? The bank answered, I was not there at that time and I cannot know what went through the borrower's mind. The attorney asked, if a lender loaned a borrower $10,000 and the borrower refused to repay the money, do you believe the lender is damaged? The banker thought, if he said no, it would imply that the borrower does not have to repay. If he said yes, it would imply that the borrower is damaged for the loan to the bank of which the bank never repaid. The banker answered, if a loan is not repaid, the lender is damaged. The attorney asked, is it the bank policy to take actual cash value from the borrower, use it to fund the bank loan check, and never return the actual cash value to the borrower? The banker said, the bank returns the funds. The attorney asked, was the actual cash value the bank received from the alleged borrower returned as a return of the money the bank took, or was it returned as a bank loan to the borrower? The banker said, as a loan. The attorney asked, how did the bank get the borrower's money for free? The banker said, that is how it works. Volume number 2 has hundreds and hundreds of questions with explanations about why these questions are asked. Each word is important, and many people change the questions to their demise. There is an art to asking questions. Legal counsel will be able to take these questions and be sure they are worded in a manner that can be asked in court. These questions were worded for textbook purposes to illustrate a point. And under Title 12, 1431, a bank has only been authorized to borrow money, never to lend money, ladies and gentlemen. And another thing, all banks are insolvent, all banks are foreign, all corporations are foreign to the United States of America, ladies and gentlemen. And I just want to point that out to be perfectly clear with you. Thank you for joining me. I'm going to keep these videos nice, short, simple, and sweet for all of you out there. So 33 minutes and 59 seconds. We'll see you in the next video, which will be called How Credit Card Companies Trick You.